The sixth step in the Supreme Court case process is the decision writing or the opinion writing. So the decision is basically that, the court ruling. What did the court decide? An opinion, okay, basically is the statement of legal reasoning behind a judicial decision. So it's the legal reasoning behind the decision the court made. Content of opinion can be broad and bold. This decision needs to be able to be interpreted by courts of the future, and broad and bold opinions have far-reaching implications for future cases. People will look to the legal reasoning behind the way cases were decided and use that as arguments in future court cases. So once Brown v. Board decided that separate was not equal, and that was the opinion of the court, every single civil rights case that came after Brown v. Board used that legal reasoning, that separate was not equal according to the 14th Amendment equal protection, as a justification for getting rid of discrimination. Majority opinion. What is it? It is the opinion of the majority. If the Chief Justice is in the majority, he's going to write it, or he gets to decide who will. Generally, the justice that writes the opinion is the justice that is most passionate about the opinion. And all 9 judges, regardless of whether they agree with the opinion of the majority or not, they're going to negotiate the legal reasoning and the rationale behind it. Drafts of the opinion are passed around and edited by the other justices. I don't want you to think that if it's a 5-4 split, like most decisions are split 5-4, the 5 justices in the majority completely run all over the opinions of the minority. They're very civil people, and they treat each other with respect, and they respect each other's opinions. So it is negotiated. Dissenting opinions are just that. These are the legal papers that are written by the justices that are opposition to the majority. They explain why they don't agree with the majority, and the reason why dissenting opinions are written, because why would you write a 50-page paper if you're a loser, is that you're hoping that courts of the future will see the legal reasoning behind why you disagreed with this ruling and perhaps overturn the decision that was made. For example, Plessy versus Ferguson. That is that decision, the court decided that separate could be equal. So it was legitimately okay to separate the races. Those justices that were in the dissenting or in the minority would have written a dissenting opinion, hopefully to sway courts of the future's legal opinion about the idea of separate but equal. Okay, concurring opinions. You support the majority ruling, but you do so for different reasons. Okay, you may agree with the 5, or you might agree with the 5-4 decision, but you might have different constitutional arguments for why that is the case, and you might write a concurring opinion. Most Supreme Court case decisions are going to reflect this idea of stare decisis, or using past cases, and allowing the decision of the lower courts to stand. Most cases, decisions of the Supreme Court reflect the decisions of the lower courts. Very rarely do cases actually set precedent. Most are ruled on the precedent already set in past court cases or by lower courts. Statutory construction. Statutory construction is an opinion that reflects the law. So the Supreme Court opinion might be more of a The legal reasoning behind it might be more based on law than the Constitution. Sometimes this is the case. Um, like statutory construction, the opinion would reflect a law that Congress has had in place for quite some time. That is rare too. But what the rarest decision reflects is a precedent or setting a precedent. The cases that set precedent are so rare that we study them. Setting precedent is starting a new legal trend. From this day forward, when a decision sets precedent, the courts of the future will decide their cases based on the precedent set in this opinion. They don't have to always follow precedent. Like, say, going back to Brown v. Board. Brown v. Board, the Warren Court wasn't like, oh, we're going to just continue the precedent set by Plessy versus Ferguson. They decided to overturn precedent set. And then start a brand new legal trend. So you can either start the legal trend or overturn a legal trend that had been in place. Either way, this is rare, and that's why we study it. This is where the original strict or judicial discretion or loose interpretation of the Constitution comes into play. If a justice sets precedent through original intent, they're going to interpret the Constitution word for word. If the justice set precedent with loose constructionist ideas, they're going to apply the framers' view to modern issues. It is key at this point that you understand the vast majority of cases that the court settles are settled on the principle of stare decisis, meaning that an earlier decision should hold. All courts rely heavily upon precedent in similar cases that were handed down in the past as a guide for their current decisions. So they'll look to what a case with a similar constitutional issue was decided or how it was decided in the past and base a decision upon the precedent already set. The Supreme Court is in the position to overrule its own precedent, and it has done so. So that is key. Most of the time they're going to rule based on stare decisis. Sometimes they can set precedent, and they can also overturn the precedent set by earlier courts. Divided decisions. The Rehnquist term, so a court is named after the justice that the chief justice that presides over the court. Sorry. So the Rehnquist court from 2001 to 2004. Okay. This is the number of decisions with dissent. Okay. And then this is the Roberts court. Okay. You can see that the on average the Rehnquist court had about a 50 average dissent, 50% average dissent, and that the Roberts court was much more contentious, especially in 2008. So that means that the number of divided decisions were a little bit more intense in 2008 for the Roberts court. Earlier in the Roberts court, the judges kind of agreed with each other. Later, they were a little bit more of a clashing group. During the Rehnquist time, he had an average of about 50% 5-4 splits or divided decisions. Now the reason is because Sandra Day O'Connor was considered a swing vote on the court. She would go liberal or conservative just based on the particular issue at hand. So a lot of times in the Rehnquist court it would be a 4-4, and Sandra Day O'Connor would be the deciding factor. Okay, now the last step of the Supreme Court case process is, well, don't pack up. Alright, I don't know why it's not showing up. Maybe it's because it's written in white. The seventh and eighth step is that the opinion is announced. Very rarely does the media cover this. Well, this is just going. Seventh and eighth. Don't know where it went. Anyway, the seventh step is that once this decision is finished, then it's announced and it's published. The media does a really bad job at reporting on it and explaining the legal reasoning behind the decision. They do a horrific job at that, except a few Supreme Court reporters like Nina Totenberg. She's been following the Supreme Court for years, and she is really good at explaining the legal reasonings behind their decision. But then the eighth step is that it has to be implemented, and that is where we go into the weakness of the court. Oh, oh, there it is. It's announced, it's published, it is ignored. Okay. Now, the one weakness of the Supreme Court is that they can't enforce their decisions. Why did I animate that like that? I thought I was being cute. All right, so implementing court decisions. That is their big weakness. Okay, they can't make their decisions policy. How and when, or even if their decisions are ever made into policy, are up to state lawmakers, Congress, and the president. I mean, you think about it. I use this example all the time. Brown v. Board was decided in 1954, and the last school district in this country to integrate was 1978, because the court had to rely on the other two branches and the states to enforce their decisions. Now, when they implement the court decisions, they have to make sure that their decisions are understood. There's an interpreting population. These are your lawyers and your lower courts that have to understand the legal reasoning behind the court's decision. Have they been able to incorporate the law into their arguments? Do cops, when cops are told that they have to read people their Miranda rights, do they understand what that looks like? That leads us to the implementation population. Those who enforce the decisions, they have to actually do it. So again, going back to Miranda rights. Now, you had people, lawyers, who had to understand what Miranda rights meant. But then you had cops who had to actually implement or carry out Miranda rights. So when somebody got arrested, they had to understand, they had to read the rights to these people. And when they read the rights to the people, and whatever that person said before they had their rights read to them couldn't be used against them in a court of law. So you have the implementation population, and then you have your consumer population. This is the public whose rights are at stake. The people, the rights of the accused, those criminals that get arrested. Do they understand what the Supreme Court decision meant for them in Miranda v. Arizona? Alright, so implementing court decisions, it takes three groups. It takes the interpreters, that's the lawmakers, the lawyers, the lower courts. It takes the implementers, those who have to enforce the policy decisions, like all the way up to the president, all the way to low-level street bureaucrats. And then you have the consumer population, and that's us, the people who are affected by this decision.